Welcome to this live discussion of landlords and the eviction moratorium hosted by the City of Milpitas Housing Department with Project Sentinel. I'm Mark Thomasy. I'm a landlord tenant counselor working for the City of Milpitas, and also I work in City of Fremont. And I'm here also with Michael Dittmer from Project Sentinel.
Hi everyone, my name is Michael. So I work in tenant landlord relations as well, similar to Mark. I handle a couple of different cities, but I also do work on the City of Milpitas with Mark. So after the presentation, if you have any questions, you're more than welcome to reach out to Mark or to me or some of the staff members of the City of Milpitas who will introduce themselves as well.
And my name is Robert Musallam. I am the Housing Authority Administrator for the City of Milpitas. And yeah, we're very happy to be putting on this presentation for you here tonight. Thank you everyone for joining us, and we hope that the topic being landlords and the eviction moratorium could not also benefit the landlord community, but also shed some light on for tenants as well who may have some uncertainty during these sort of troubling times. So with that, I will start the presentation and we'll get going. Okay, so right off top, just want to introduce our partners. Silicon Valley at Home is a proud partner of the City of Milpitas, and they have been putting on Affordable Housing Week for quite some time, and this month they're gracious enough to host Affordable Housing Month. In the City of Milpitas, May is also known as Affordable Housing and Building Safety Month, so it's quite the unique opportunity for us to co-host an event with our partners at Project Sentinel and our partners at SV at Home. As you know, affordable housing is a challenging topic, and it's very critical for us as a community to establish that. And so it's more important than ever to hear our partners and work together to create more affordable housing. And so for all of their events, past and future, you can visit the link, which we'll put in the chat box towards the end of the presentation. So you can check out the rest of SV at Home's calendar and their events. Okay, so also just wanted to give a shout out to the generous sponsors for Affordable Housing Month as listed here, and shamelessly plug that the City of Milpitas is a wonderful bronze sponsor for SV at Home. So we're very proud of that work, and very happy with the relationship and the work that we do to promote affordable housing initiatives in the community. Okay, enough of that. So I will move on and allow Mark to begin his presentation.
Okay, next slide. Great. Okay, so I assume probably most of you are here are aware of the eviction moratorium that was enacted by the Santa Clara County Board of Supervisors. So basically we're going to, next slide please. Basically we're going to cover today, we want to try to leave as much time as possible, hopefully at least a half an hour, to answer any questions that the attendees that you have brought with you here today. So I just want to go through the basics of the ordinance very quickly, cover some of the basics. And so we're going to talk about, first of all, the basic details of the ordinance. We're going to talk about the documentation that tenants are required to provide to landlords if they believe that they're eligible for protection of the ordinance. We want to talk about tenants' obligation to pay rent ultimately. We're going to cover when owners can terminate or evict a tenant, and very briefly some temporary changes to the eviction process, and then issues raised by the county ordinance, and then of course your own issues or questions. Next, please. So the basic details are that the moratorium was enacted as an urgency ordinance on March 24th. It's scheduled to expire on May 31st, unless it's shortened or extended. As it stands now, the Board of Supervisors is scheduled to consider extension of the ordinance on May 26th. It applies to both residential and commercial small business tenants, small business as defined by the Federal Small Business Administration. They have a table that lists what properties are considered small businesses. Generally, it's businesses that do $8 million in revenues per year or less, although there's a few types of businesses, such as convenience stores, where that limit can go up to 20 million per year in revenues. So basically, what the ordinance does is it prohibits the termination of tenancy for two causes. First, failure to pay rent if directly related to a substantial loss of income or substantial out-of-pocket medical expenses associated with COVID-19. Secondly, it prohibits any no-fault cause of eviction, as that term is defined in Civil Code Section 1946.2, but only if the tenant has had a substantial loss of income or out-of-pocket medical expenses associated with COVID-19. The tenant, of course, must demonstrate eligibility either through documentation or other objectively verifiable means. And ultimately, the tenant is not relieved of that obligation to pay rent. It's simply delayed. Next slide, please. The documentation that tenants must use to demonstrate is either a substantial loss of income related to COVID-19 from things like job loss, layoff, reduction in work hours. If it's a business, then you're looking at closure of the store, restaurant, office, or business. Reduction in opening hours or consumer demand, the need to miss work due to child care for a child or an infected family member, or other similarly caused loss of income. Also, the substantial out-of-pocket medical expense for tenant or immediate family member related to COVID-19. Adequate documentation can include, there's a few things that are listed: letters from employers, paycheck stubs, bank statements, letters from schools. Next slide. As I mentioned, the obligation to pay rent it doesn't go away. It's not forgiven. The tenant has 120 days after the expiration of the ordinance to pay all past due rent. During that period of time, during the period that the ordinance is in effect, and for the 120 days thereafter, the landlords are not permitted to charge late fees on the delayed rent payment. Next slide, please. So, when can an owner terminate or evict a tenant? Well, of course, after the ordinance expires. And also, anytime if the tenant is not eligible for protection and receives notice of reason for the termination of tenancy, notice of the tenant's rights under the ordinance, and notice of emergency rental assistance programs. So under the ordinance, any termination of tenancy notice that's given while the ordinance is in effect actually has to have these three items in that, with that notice: the reason, a notice of the tenant's rights, and the notice of emergency rental assistance programs. At the end of the presentation, there's going to be a link to the county website where they actually have provided, the county has provided forms that, that landlords can use to provide the required information when they're giving a termination of tenancy notice. Of course, landlords, owners can also terminate a tenancy if the tenant's not eligible for protection, if they haven't been impacted by COVID-19. The tenant is not eligible for protection if there is an at-fault cause for termination other than non-payment of rent. And the tenant is also not eligible for protection if there is a no-fault cause for termination that is not defined by Civil Code 1946.2. And the 4 defined reasons for no-fault causes of termination under Civil Code 1946 are owner move-in, withdrawal from the rental market, government or court order, or intent to demolish or substantially remodel the property. So let me just pause there for a moment. We had a case where the landlord, this is while the ordinance was in effect, the landlord had provided the tenant, served the tenant with a 60-day termination of tenancy notice. The landlord had listed the reason for the termination as owner move-in. The tenant, in fact, had been impacted by COVID-19. Both the husband and wife had lost either all their jobs or had reduced hours. However, the effective date of the termination was June 30th. And so even though on its face it looked like that would be a termination that would be in violation of the ordinance, because the effective date of the ordinance was after the expiration date of the ordinance, then assuming it's not extended at least until June 30th, as it stands now, that termination of tenancy notice was actually valid. Basically, any other no-fault reason for termination of tenancy that's not one of those 4 reasons listed in Civil Code 1946 would essentially, even if the tenant had been impacted by COVID-19, would theoretically be a valid termination of tenancy notice. Next slide, please. So in addition to the impact of the temporary moratorium on evictions, this county ordinance, there's a couple of other things that have temporarily affected the eviction process. One of those is court closures. Many of the parts of the court system have been closed down, at least partially, if not entirely, over the last couple months. There are some departments that are open that are handling certain things like restraining orders, certain types of family law orders. But in general, the courts have been closed down. So, of course, even in cases where landlords want to file evictions, it's simply not possible because the courts aren't taking these cases. The courts seem to be starting to open up now. But the thing that's really going to delay the process is a judicial council emergency order that was issued on April 6th. And basically what that says is that for 90 days after the governor declares that the COVID-19 emergency has been lifted, the court is not going to issue any summons in unlawful detainer cases unless necessary to protect public health or safety. So, you know, if the courts are open, you might be able to file an unlawful detainer, but the court won't issue the summons on the case. So it doesn't move anywhere, it doesn't go anywhere. So obviously there's going to be some long delays in the eviction process going forward. Next slide, please. I think we missed one. There we go. Okay, so some of the issues that we've seen raised by this temporary moratorium on evictions are, this is one that's come up a few times, is how much documentation is actually required. So we've had cases where the tenant has lost their job. They've provided a letter from their employer proving that fact, that they've been either laid off or lost their job permanently. And then the landlord, the owner, says, well, okay, that's fine, but show me your bank statements. How do I know you don't have plenty of money in the bank and you could pay rent? So there's nothing in the ordinance that says how much or exactly what types of documentation the tenants are required to provide in order to be protected. So it's really a case-by-case individual situation. There's nothing that says you can't ask for, if the tenant gives you one form of documentation, there's nothing that says you can't ask for a second form or third form. But there's also nothing that's in the ordinance that says a tenant is required to provide those. The same type of issue comes up with partial rent payments. There are some eviction moratoriums in other counties and cities where it actually states that if the tenant has some ability to pay partial rent, then they should, right? So, but there's nothing in this particular ordinance that states anything about making partial rent payments. So again, it's not something that's required by the ordinance, but it's also, the owner's not prohibited from asking. In the same way, tenants have come to us and said that the landlord is pressuring them into signing a repayment plan agreement, or some like a promissory note. Someone mentioned today the landlord was trying to force them or encourage them to sign a promissory note. Well, there's nothing in the moratorium about that. So again, it's not required, but it's also, there's no prohibition on the owner asking for those things. And basically, I encourage tenants to, in order to try to keep a good relationship with their landlord, I encourage tenants to provide a reasonable amount of documentation. And, the reason is really to try to assure the landlord that the tenant isn't trying to take advantage of this situation in order to keep a good relationship. I sort of touched on this next one earlier, but if a termination, the question is whether a termination notice is valid when the effective date is after the expiration date of the ordinance. And the answer is yes. But again, if the ordinance gets extended, then the termination notice at that point would be invalid. So something to keep in mind. We've also had a couple of different types of situations where the tenant has questioned the reason, whether the reason for the termination that the landlord is providing is true or not, is accurate. We've seen this in, I've seen this in shared housing situations where the landlord, we had one where the tenant was given a 3-day notice, unconditional 3-day notice to quit, to move out immediately. The landlord was listed some supposed violations, like the tenant was being too noisy, wasn't always locking the front door, things like that. And the tenant really sort of suspected that maybe the true reason wasn't those things. Perhaps the true reason was that being in a shared housing situation, the tenant it was right after she'd had a friend over for a dinner, and she thought that perhaps the owner was starting to get nervous about being exposed to the coronavirus, and that perhaps was the true reason for the termination, for his own protection of his own health. Okay, let's go to the next one. So, as I mentioned before, This is the link to the county ordinance information, the required forms. And then there's our contact information for counseling. You can call us, you can email. We provide not only free, neutral, and confidential counseling for both tenants and landlords, but we also provide mediation service. And, you know, we can, if you're having a problem with your tenant over perhaps trying to negotiate the repayment, or problem with whether the tenant is providing adequate documentation or any documentation, we have mediators. We have panels of volunteer mediators that are available. If both parties are willing, we can set up, you know, normally we do in-person meetings, but at this point, I assume we're still going to continue to do Zoom meetings, but they'll be able to conduct a mediation, especially with if there's a real need to try to negotiate a termination of the tenancy, some mutual agreement between you and your tenant to move out. Given the situation that I talked about with the courts being closed down, this long 90-day moratorium on any movement of eviction cases through the courts, perhaps going to a mediation process with your tenant to try to resolve issues like a mutually agreeable termination is something that hopefully would be helpful to you. So, let's see. At this point, I think I saw some questions coming in.
Yeah, let me get you some questions here. So if you do have some questions, and thanks, Mark, for that presentation. That was very helpful. Had a comment here that there was really great overview from Jovan. So thank you for that information. If you do have questions, you could ask questions in the chat box, or you can ask in the Q&A. I have a question here from Nina. It says, how should caseworkers advise tenants that are not protected because they do not have a rental contract or are unable to get one from their landlord because of this situation and their current inability to pay rent?
Okay, so tenants always have a rental agreement with the owner, with the landlord, even if it's not written. Verbal rental agreements are perfectly legal. They're not advisable because there's often disputes about what the terms of the agreement are. But as long as the tenant was allowed to live in the property with the owner's permission, or in the case of a subtenant with the master tenant's permission, then they are a tenant and they have all the rights of any other tenant. So they are protected under all the laws, including this moratorium on evictions. So I would say if the tenant needs some, you know, my recommendation would, of course, be to refer the tenant who's going through that and may not realize or may not think they have, that they are protected because they don't have a written agreement. Generally, if a tenant has lived in a place for more than 30 days with the owner or the tenant's permission as a subtenant, then they're protected. They have all the rights of any other tenant, and including those under the county moratorium. So I hope that answers your question.
Okay, and so just in general, Mark, I think landlords right now are sort of wondering, you know, how will they receive the rental income to pay for their expenses, mortgages, or employees in some cases. Are you able to speak to, you know, what's going on with the temporary moratorium? Are there any updates as far as you know as to when the moratorium may be lifted, or how the repayment situation might work? Anything that you could speak to?
Well, we know, the only thing I know, as I mentioned at the beginning, is that the County Board of Supervisors is going to consider extending the moratorium on May 26th. We don't know if it's going to be extended or not. My guess would be if they do, it might be extended for another month, and then they'll do it on a case. You'll just wait and see how it goes from there. But in terms of repayment, I mean, it's pretty clear. Once the moratorium expires, the tenant is expected to repay the overdue rent within 4 months, 120 days. And if they don't, at that point, the owner could serve the tenant with a 3-day notice to pay rent or quit. If they still don't pay and they don't move out, then the owner could file an eviction. The owner could also take the tenant to court, small claims court, or Superior Court, limited jurisdiction, should be able to get a judgment. And once a landlord has a judgment, there are ways to collect on that judgment, particularly if the tenant is working. They can do wage garnishments, levy bank accounts, things like that. There are ways to collect. Now, if the tenant is not working, if there's no money in the bank, that's another matter.
I think this would be a good opportunity just to mention that, the city does have a pilot rent relief program. We are currently assisting individuals that are unable to pay their rent due to COVID-19. So if you as a landlord or anybody that works in the landlord community, or if you know anybody that might be impacted that lives in the city of Milpitas, we encourage you to reach out to myself, city staff, housing staff at the city, and we will put you in touch with our partners at Silicon Valley Independent Living Center who administer this program for us. So if you do know anybody that is suffering a hardship, please have them reach out to us, and we'll make sure if you email Mark, or if
Yes.
you can put our contact info back up on the screen, that we'll make sure that you have a way to connect with us.
Right.
Okay. If you have any questions, please feel free to enter them into the chat box. Actually, I'm just going to move this slide back to the front with our contact info. Not too far. How about small businesses, Mark? What do small business tenants need to know about this? Have you received any calls about just what are their rights, and how does this apply to them, and what sort of general information can you offer small business tenants or possibly commercial landlords who might be on the call?
Right. Well, I've only had one small business commercial tenant who called me, who had a question about the documentation that was, their business, of course, had shut down during this period, and they had they had very reduced income. They were still doing some of their business online, but I think their business had been reduced by about 75%. So they had some income, but certainly not enough to pay rent. So they were trying to work out something with the landlord about paying whatever they could, or much or none. And there was a sort of a issue about how much documentation they needed to provide. Obviously, the fact that their business was closed was obvious to the owner. Could see that they weren't operating the way they normally did. But the owner wanted to see their bank account, wanted to know how much money they had in their account. And the tenant was a bit reluctant to provide that because, in fact, they did have some money in the account, but they also didn't know how long the situation was going to continue. Of course, he had a lot of other expenses, and so they were reluctant to share that information. So they wanted to know, do they have to? And I said, well, there's nothing in the ordinance that requires you to provide that specifically. So, but that was the only one we've had from commercial tenants. But the protections are exactly the same as they are for residential tenants in terms of the protections. So,
Mark, just maybe a follow-up question. We have through our pilot rent relief program, we are also in the same boat where we are trying to document a verifiable COVID-19 verifiable need due to COVID-19, and I'm curious, how would, say, a text message work as proof that you're from your employer that you're suffering from, that you're affected by COVID-19? How would a text message hold up on your end if you were trying to prove that this individual had a need for rental assistance?
Well, I imagine the owner might want to see something a little more substantial than that. I would think they might want to see something on a company letterhead or.
Yeah, and forgive me. Let me just clarify. So I think I'm speaking about a subset of tenants that maybe are undocumented and
Okay.
might work construction, let's say, and so the boss sends them a text and says, hey, construction is prohibited right now, and there's no work.
Right.
There's no letterhead. There's no official company memo.
So the ordinance says documentation or other verifiable means. So it does acknowledge the possibility that there are people who won't be able to provide paper documents, and so it allows for that. So I would think if the landlord could call the sender of the text message, the tenant's employer, and talk to them in person, and get some assurance that in fact their tenant is out of work, that should be sufficient.
Okay, we had a follow-up question here. It says on the same note of documentation, if the tenant has no way to contact their employer, or if they are self-employed and making cash income, what kind of documentation might be allowed? Would a self-declaration work?
Yeah, the county ordinance doesn't specifically include self-documentation. Like the county, Alameda County ordinance does have a provision for that, self-documentation, but the Santa Clara County ordinance does say other verifiable means, so it's pretty broad. So, it's pretty broad.
What other protections are available for a landlord at this time that you're aware of? I know that the eviction moratorium, limits them from doing a lot, but and similarly, I believe that the eviction courts actually just shut down, right? So that anything that was in process is also on hold.
Right.
Is it the expectation that those are going to pick up where they left off, or they have to start all over again in terms of timing? Can you speak to anything like that about where a landlord might have already been in the eviction process with a tenant and
yeah. I think what I saw is those ones that had already been filed were automatically extended by 60 days. But yeah, theoretically, once courts open up, then that process will go through. So, but yeah, landlords are in a really tough spot right now. For ones that really do need to have a good justifiable reason to want to terminate or evict their tenants, they are in a really tough situation right now. So that's why I really try to encourage landlords to talk to their tenants, consider negotiating with them, using our service for mediation whenever possible, because they don't have a lot of options right now if they're having problems with their tenants.
Okay, we got another question in here. It says, what would you recommend for tenants and landlords that want to find a mutually workable solution in this challenging time without anybody giving up rights they enjoy? Is there a best practice? And how do we get the word out to everybody so they go into these conversations understanding all of their rights and obligations?
Well, the best way for them to understand all their rights and obligations is contacting us. We'll send them information. We have a lot of information I send out by email, links to different websites, try to organize and keep the information as updated as possible. And then to try to work things out with their tenants, between tenants and landlords. Again, our mediation service is what we offer to help tenants and landlords do that.
I have I have a question here. It says, I want to move my son into one of my units. Can I pay my tenant $5,000 to move out so I can move my son in?
Yeah, that would be a mutually negotiated termination of the tenancy. So if it's within Santa Clara County right now, that would be one of those reasons it is covered by no fault, the prohibition on no fault evictions, specifically for owner move-in. And owner move-in includes close family members. So generally, that would be an allowable, justifiable reason if the property was covered by just cause eviction requirements. But under the county moratorium, it's specifically prohibited. But again, only if the tenant has been impacted by COVID-19. So I'll assume, for the sake of your question, that the tenant has been impacted. Then while the ordinance is in effect, the only way to do that would be to for the tenant and landlord to mutually agree to a termination of tenancy. And certainly landlords, it's not uncommon for landlords to pay tenants to move out rather than have to wait and go through what can be a very lengthy eviction process, even in normal times, which is greatly extended right now.
Mark, I think we had a case a few weeks ago. We didn't talk about this ahead of time, so forgive me if I'm putting you on the spot. But we had an owner that was given a notice to vacate from a property they were renting in another county that didn't have the eviction moratorium that protection that we have, and so subsequently they were going to move back to Milpitas, and they wanted to move back into the house that they owned, and now there's this eviction moratorium here, and their tenant is unsure what to do. How does this apply? I know there's a lot of gray area, right? How does this apply to a situation like that where somebody wants to move back in because now they're put in a precarious housing situation? How do those two things work out? Because it's not like the landlord is trying to kick them out. It's the reality is that they're being vacated and now they need shelter themselves. So how do those two things work out, or how can they work out?
Well, again, if the tenant is protected by the moratorium from any termination of tenancy for that reason, owner move-in, then the only way it's going to work out is if the tenant and landlord come to a mutual agreement on the terms of that termination. So, even though tenants are protected by the eviction moratorium, they can certainly waive their rights to be protected by the eviction moratorium and agree to move out if an agreement's reached.
Okay, so even if an owner was in that kind of situation, they still, under this moratorium, could not request they can't end the tenancy with that particular tenant.
Yeah, I mean, again, it's one thing. I mean, even if they gave the tenant a termination of tenancy notice, if it violated the ordinance, then of course the tenant has a defense if it did go forward to an eviction. But just because a landlord gives a termination of tenancy notice, it's not self-enforcing. If the tenant doesn't move out when the landlord thinks the tenant should move out, the landlord has to go through the eviction process, which is, as I said, even in normal times, this can be a very lengthy process of several weeks, sometimes months. So there's really nothing the landlord can do to get the tenant out without a court order from the courts through the eviction process. And then, of course, that gets enforced by the sheriff's department. That's the only way to legally get the tenant out.
Yeah, let's touch on that in a second. So we had a question here. Does the moratorium apply to Section 8 rentals as well?
Yes.
Okay, just to clarify.
Yeah, no exception or there's no distinction for Section 8 tenants.
Okay. You just mentioned a situation where a tenant might be asked to leave the premises. Can you expand on that? What are the types of situations where the sheriff might come out and forcibly remove a tenant from their home?
Well, if the owner gets a judgment to retake possession of the property that's issued by the court as a result of the eviction, the unlawful detainer eviction process, then the sheriffs will come out. They'll post a notice to vacate on the door. The tenant will know exactly the date the sheriffs are going to come back to remove them. It's usually around 10 days after the date the notice is posted, sometimes a day or two less. And if the tenant is still there, that's when the owner retakes possession of the property. That's when they can change the locks. If the tenant is still there, the sheriffs escort him out of the property. And that's it. That's how it happens.
Okay. So, I mean, I know, at least I've seen studies or reports that, incidences of abuse have increased as everybody's sheltering in place. So those are still situations where, a landlord might be able to take a particular action against their tenant if there is some sort of crime being committed, for instance.
Yeah. I mean, the courts are still open for restraining orders. So if there's a domestic violence or elder abuse restraining order that's issued, that is a way that people can be removed from a residence. But that's usually going to be a family member or a co-occupant of a tenant in a property, whether it's a rental property or otherwise. I haven't heard of, I guess in a shared housing situation, I guess I could imagine a landlord and owner in a shared housing situation, perhaps getting a restraining order against an abusive tenant in a shared housing situation. But that might be the only way that would happen relatively quickly.
Yeah, I think shared housing is probably one of the larger unknowns for the moratorium. I've at least spoken to a lot of people in shared housing situations that don't really understand that they have rights, even though they don't necessarily have a lease agreement. And so if anybody in the community runs into somebody that has sort of, I don't want to call it a gray area situation, but would it be preferred to just direct them to your office and have you consult with them to just make sure they understand what their rights and obligations are?
Yes, definitely.
Okay. Do you have any examples of that off the top of your head that you can think of a shared housing situation that, something that maybe can illustrate the sort of rights that somebody in a shared housing situation has without a lease agreement in place? Mm-hmm.
Well, again, just what I was saying, even if there's nothing, and often there isn't anything in writing. Sometimes they have a house, they have a small property, they want to rent out one of the rooms for a little extra income. They also don't want to report that income, that rental as income on their taxes. So they require only cash payments. They don't give receipts. And so there's no written rental agreement. Everything's verbal, everything's very informal. But those tenants are tenants, and they have the same rights as any other tenants against any type of improper eviction, habitability. They have the same rights as any other tenant. Just because it's verbal doesn't mean they don't have the same rights.
Okay. And that's a fair point. I know a lot of individuals in that situation are sometimes timid to come forward for fear of retribution. What should landlords know about that aspect of it? Not saying that they're going to directly respond with a threat or anything, but are there landlord retaliation laws in place, for instance, to kind of prevent anything like that from happening?
Yeah, well, there are laws to prohibit retaliation by landlords against tenants who exercise any legal right. It's very broad. Whether it's sometimes tenants move into a room, they rent a room, the landlord doesn't want to turn on the heat, for example, and save money. And so the tenant will call the city code enforcement officer to try to put pressure on the landlord to restore the heat to the house. So if the tenant gets a termination notice after that, gets kicked out, or any other negative action within 6 months, it's presumed that that action was in retaliation for the tenant exercising their right to live in a place that has heat. So, yeah, I mean, it does happen, certainly, but there are laws to protect tenants if they're willing to use those laws. And so.
Question just came in. Are mediations available in Spanish and other languages?
That's a good question. Michael, do you know on that?
Well, he's muted. Let me unmute him real quick.
Sure.
All right. Go ahead, Michael.
Right. So this is about mediations in different languages, right?
Yeah.
Yeah. So we are working on, so like, I know that for the Hayward program, if you want a mediator, we try to locate one, and then, like as you do that video conference, then the mediator will be there too, and they'll be able to translate either on behalf of the tenant or the landlord, whoever needs the mediation service.
Project Sentinel does subscribe to a language service. We normally use it when we're talking to somebody, either back in the old days when we had visitors to our office. I would get the language service on the phone and put it on speakerphone, and they would translate that way. Or if a call comes in, we can use the language service. So I don't see any reason why we wouldn't be able to use the language service in a mediation setting, in an online mediation setting. I would think we should be able to do it. I can't say that we've had any requests for that yet, but it seems possible.
Yeah, and I should mention too that again, we have the City of Milpitas has a pilot rent relief program designed to assist individuals who are at risk of being displaced or evicted due to non-payment of rent. We partner with the Silicon Valley Independent Living Center to administer that program, and they have Spanish speakers and other languages available on staff as well. So we highly encourage you to spread the word about the pilot rent relief program. It's also something landlords should know about too. As much as these things are tenant focused initiatives, these funds go directly to landlords and help people stay housed. So we really think it's a win-win here. So we encourage anybody listening to, if you know anybody in Milpitas that's having a hardship, please have them reach out. I believe, I can't actually tell, but I believe the slide is still up with all of our information.
Yeah.
So I'm Robert from City of Milpitas Housing Department, and that's my email up there. But we will have all of this information available for you as well. We can email it to you after the event. I don't have any other questions. Any final questions before we sign off? Give you a couple seconds here. If you can, we would encourage you to go to the chat and just quickly place how you heard about this event this evening. It really helps us in terms of our outreach and marketing.
We'd like to know if anyone heard about this event tonight from a flyer they received in the mail in the last couple of days. That would be helpful for us to know. Or if you saw it on social media, perhaps one of the platforms. So it would be very helpful. Thank you.
Yep. And again, this is a really great partnership with SB at Home and their Affordable Housing Month. City of Milpitas again does Affordable Housing and Building Safety Month in May. So it's a really nice partnership opportunity for us to host an event, and we're really grateful for the partnership with Project Sentinel and all the great work that Mark and Michael and everybody at Project Sentinel does for the community. So once again, my name is Robert. I'm with the City of Milpitas Housing Department, and we thank you very much for attending our event. If you have any questions, I'll be hanging out here for another 10 minutes in case something comes up. Feel free to reach out anytime. And again, thank you very much for attending our event. We really appreciate it. Thanks, Mark. Thanks, Michael.
Thank you, Robert. Thanks everyone.
do that. Then,
It's still recording.
yeah, I'm working on it. There we go.